CFPB tried to collect from
that
him.
may be something we'll seek clarification of from your friends. With respect to the request for the hearing, why else would you be entitled to a hearing?
Well, we think that there were genuine issues of material fact in dispute relating to what the correct amount was, but principally it has to do with, as Your Honor said, reducing that amount, which could be considerable. As we documented in our brief, there was, in the record, there's about $124 million in judgments and settlements, and we approximated about $25 million had been already collected. That was 2 years ago. We know that there was additional monies collected since then. So we're talking about a substantial reduction in that, which could affect the civil penalties as well. And of course, under civil penalties, we're contesting that Mr. Wen was entitled to, now under the Jarsky opinion, was entitled to a jury trial on that issue. And if there's no more questions, I'll reserve the remainder of my time.
All right. Thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court. Amanda Krause on behalf of the Consumer Financial Protection Bureau and with their consent arguing on behalf of all plaintiffs appellees. I'd like to start by setting the table a little bit. The summary judgment record in this case is clear that Mr. Wen is liable for his role in a deceptive student debt relief scheme.
Actually, I'm sorry, but if you could actually turn to one issue that I'm trying to understand, and I want to make sure I'm clear on your position.
Sure.
If 5565C3 requires the court to take into consideration the size of the defendant's financial resources, there's a pending motion, or excuse me, a pending pleading by Mr. Wen indicating that he's satisfied the information that was requested as to why he couldn't pay, what his financial resources were. And that's sort of out in the ether out there. I don't think that the court has, district court has ruled on that. But then, but if should we send it back so that the court can consider that before issuing the civil penalty?
No, Your Honor. This court can affirm the judgment on the penalty on the record before it. The issue that's pending before the district court is a pending motion for contempt filed by the receiver in this case for Mr. Wen's failure to turn over assets in violation of the final judgment. In the course of that proceedings, Mr. Wen has recently raised some new evidence in opposing the judgment. But I think the question of whether he has complied with the judgment is a separate question from whether the judgment is proper in the first instance. And the new evidence that's been brought up before the district court de facto was not before the trial court when the court entered the judgment. And so if Mr. Wen believes that judgment or that new evidence should have changed the judgment, the proper avenue for that would be a Rule 60B motion. It wouldn't be belatedly raising it for this court on appeal to overturn. But so turning just to directly answer your question about the size of financial resources, to start, that was only one of many factors that the district court was required to consider in assessing the proper penalty. And the court, although it did express some skepticism about whether an ability to pay was the required, that the court was required to consider his ability to pay, it nevertheless took into account Mr. Wen's sizable cryptocurrency assets that were found through an earlier contempt proceeding that Mr. Wen had concealed in violation of an asset freeze.
But do you agree that even considering those concealed cryptocurrencies, that the size of that as compared to ultimately the fine, doesn't that play a role in this particular analysis? I mean, that was certainly a large amount fine. What was it, 140?
The penalty was 148 million, but the restitution at issue in this case is over $95 million. And again, Mr. Wang was held jointly and severally liable for that $95 million in restitution.
And on that point, just after my exchange with your friend, the district court, you agree that the district court order says that any amount contributed as restitution by other defendants will reduce the defendant's
Absolutely.
liability. So
Yes.
it is joint and several.
Correct. The final judgment explicitly says that the order of restitution was joint and several. We do not dispute that any amounts that have already been collected should offset Mr. Wang's liability. If there was a genuine dispute of material fact as to some of his liability, then of course that may need to be recalculated. I'm happy to discuss why there in fact was not a genuine dispute of material fact. So no, there's no issue with respect to the
Back
offset.
to the civil penalty, though, I am troubled by the fact that even though there's supposedly cryptocurrency out there somewhere, it's not real in the sense that we don't know how much it is, where it is, you know, it's just out there. And what he has shown is that he doesn't have an ability to pay almost $150 million in a civil penalty.
So Mr. Wang is the one who created the uncertainty over the size of his financial resources. And again, I'll just remember that that's only one factor to be considered, weighed against many other factors, including the fact that the size of the gravity of the violations at issue in this case were very severe.
Well,
This
one
is-
of the other factors is his good faith, which the court is supposed to consider as well.
Correct.
Which is what you're saying.
Yes, and I think that Mr. Wang's course of conduct over the course of this case certainly establishes that he did not demonstrate the requisite good faith to get any mitigation of the penalty. That's demonstrated by the fact that he shifted company operations to try and conceal the company's operations from law enforcement. He deleted emails and text messages once the company's operations were coming to light. And then he hid assets in violation of a court-ordered asset freeze. And so Mr. Wang's long course of conduct, particularly with respect to the cryptocurrency, demonstrates both that the size of financial resources is probably not a factor that the court was required to mitigate here, and also that he demonstrated bad faith. So just to walk through a little bit about the evidence of the cryptocurrency. So to start, on a financial disclosure form that Mr. Wang was required to complete through the preliminary injunction, he first stated that he had no cryptocurrency whatsoever. When the Consumer Financial Protection Bureau discovered that there were some inaccuracies in his withholding or in his statements, we pressed him on that. And only at that point did he disclose for the first time that he had some cryptocurrency, but not all of it. Then after a show cause hearing on the Bureau's first motion for an order to show cause, he then disclosed slightly more, but still not everything. He really, through the course of this case, has only provided information when pressed by it and when required through evidence that made it clear that he simply couldn't hide it any further. The district court in the first order to show cause hearing described Mr. Wang's conduct as a cat and mouse game, which I think is exactly right. So again, he's the one that created the uncertainty about the size of his financial resources, which I think shows that it's appropriate that the district court didn't mitigate the penalty on that basis.
On the penalty, as I understand it, it was you counted every single day of the period, 3 violations per day. What are we supposed to do with the fact that it seems like it is unlikely that, or I guess, give me a sense of your logic here, where the violations were charging enrollment fees, which as I understand would be one time per client or victim, charging recertification fees, and I think those were more periodic, and then the deceptive conduct, which would involve communication to each member of the class. What's the Bureau's theory as to what it has to show to establish that all 3 of those violations, some of which are quite discrete in time and periodic and not continuous, actually I think all of them are, were happening at each point in the time period?
Sure, Your Honor. So the statute under 12 U.S.C. 5565C states that a penalty should be assessed for each day that a violation continues. And so here, this is a course of conduct that began on November 5th of 2015 and continued until, I believe, October 19th of 2023, or 2019, excuse me. And so those practices, those company practices began at the beginning and continued throughout that period. But if the district court was supposed to take into account each individual violation, so for instance, each illegal advance fee, that would be the case of the court charging at least, or the court accounting at least 80,000 distinct violations, which if you just do that for 80,000 violations one day at the second tier of penalty, would amount to, I believe it was $2.5 billion in penalty. That far exceeds.
So this is the more lenient approach, actually.
Indeed.
Okay.
So how many victims were there?
Over 80,000. I don't have the precise number, but I know it was over 80,000
And that
consumers.
was established?
Correct. Undisputed by Mr. Wang.
Okay.
And I'll just also note, Your Honor, to Judge Johnstone, the giving this sort of how to, district courts do have discretion to like consider what constitutes the violation of in a particular case and setting the penalty. It's consistent with this court's decision in the SEC v. Murphy case, the 2022 case. There was the court noted that district courts have discretion to determine what counts as a violation and can use various proxies, including the number of investors, number of fraudulent transactions. That was an SEC case, but a similar statutory scheme. I'll turn back now with the time I have to just discuss the, I'd like to correct just a couple of things that Mr. Isaacs raised about the motion to reopen discovery. I think Your Honor's questions make it clear that you understand there was no abuse of discretion on the part of the district court in denying that motion. I'll just note briefly, though, that there's evidence in the record that when Mr. Wang was confined in FCI Sheridan, where he claims now that he was effectively incommunicado, there's evidence showing that Mr. Wang simply refused communications with plaintiff's counsel, which prompted a motion to compel. The court did order him to compel responses to discovery. It's detailed at 1 ER 71 in the district court's order denying the motion to reopen discovery. And then also, Mr. Isaacs says that Mr. Wang didn't receive Mr. Kim's declaration until the motion for summary judgment. That's false. Mr. Wang was served with Mr. Kim's declaration in October of 2022 while he was at the residential reentry facility, where he also had access to email, including showing that he responded to plaintiff's discovery requests, written discovery requests in October of 2022. I'll turn now to addressing the motion for summary judgment. So there's no dispute on appeal that Mr. Wang is liable for the period after June 2017. The only thing that he disputes on appeal is whether he is liable for the period between November 2015 and June 2017. And there's a plethora of undisputed evidence in the record to show that Mr. Wang was both directly liable and liable as a substantial assister in violation of the TSR and the CFPA. To establish that he was directly liable for the violations, plaintiffs had to prove that he participated directly in the violation or had authority to control them, and then also that he was at least recklessly indifferent. Substantial assistance is actually a lower standard. We only had to prove that he provided some substantial assistance to the company and also had some reckless indifference to the company's conduct. I'll note that Mr. Wang barely addresses the substantial assistance standard in his briefing, perhaps because it's very clear that the standard here is met. And so I'll walk quickly through the evidence of his authority to control and substantial assistance before turning to the mental element. So on authority to control, first, there are documents that show that Mr. Wang was the company's general counsel beginning in November of 2015. He was also listed on a document as the company's chief financial officer. He was a signatory on bank accounts and merchant accounts, including accounts that were active between 2015 and 2017. He was an equal owner of the company with Mr. Kim from the very beginning. That was a point that he conceded in his own declaration opposing the motion for summary judgment. And he responded to or reviewed consumer complaints, including during the period that he calls period 1. For substantial assistance, all of that evidence clearly shows that he had the authority to speak for and sign documents on behalf of the company, which shows the requisite ability to control it for direct liability. For substantial assistance, all plaintiffs had to establish is that he provided more than mere casual or incidental assistance to the company. Again, here, he was the company's general counsel. In his own declaration, he notes that he provided help with budget issues. That is enough, more than enough to meet that threshold. With respect to the mental element, again, there's plenty of evidence, undisputed evidence in the record to show that Mr. Wang knew of or consciously avoided knowing of the company's violations. That's shown by a November 2015 agreement that Mr. Wang signed as general counsel, acknowledging that the company had to comply with the telemarketing sales rule and the Consumer Financial Protection Act. Again, he's the general counsel, and yet he took no steps to ensure the company complied with those laws. He also discussed the company's fee schedule with Mr. Kim in an email in period 1. That's in April of 2016. That email is at 1 SER 95. Mr. Wang also acknowledged in his declaration that Mr. Kim had made him aware of the alterations to consumers' family sizes in their income-driven repayment plan applications. And again, he reviewed and responded to consumer complaints, including consumer complaints that acknowledged that the company had charged illegal upfront fees, and he responded to a consumer who complained that she had been scammed because the company inflated her family size on the loan application. And also, all of this evidence is only what remains after Mr. Wang undisputedly deleted company emails and his text messages through the course of this proceeding. So all of this evidence is sufficient to show that Mr. Wang was liable, both directly liable and as a substantial assister in violation of those laws. Unless your honors have any further questions, we ask that you affirm the judgment below.
Thank you, counsel.
Thank you.
Mr. Isaacs.
Thank you, Your Honors. Real quick on this issue of the cryptocurrency. I believe counsel said there was that this is new evidence that Mr. Wang is putting forth, and that's not correct. The district court's contempt order was entered on January 6, 2023. It had included in it 2 purgation provisions with a deadline of January 17th, 2023. And this required Mr. Wang to make detailed disclosures. He, in fact, filed a lengthy and detailed declaration on January 17th, 2023, prior to the deadline. And since that time, neither the CFPB nor the receiver have ever challenged that showing made by Mr. Wang. So we have 2.5 years during which they've never challenged it. They've not produced any evidence that he is somehow still holding cryptocurrency secretly. And furthermore, the contempt order provided for a $1,000 a day sanction if Mr. Wang failed to purge himself. The district court was never asked to impose that sanction, never did. That ruling merged with the final judgment.
Counsel, what should we do about that motion? Should we do a limited remand or?
I think certainly, well, that motion has now been under submission, was filed, I think in August it'll be 2 years, and in September it'll be under submission for 2 years. That's the receiver's motion, post-judgment, to have Mr. Wang held in contempt. When we came into the case, we filed a supplemental memo asking that the district court deny the motion and also find that Mr. Wang had purged himself of the contempt, which by complying with the purgation provisions, these are the district court's purgation provisions, nobody's challenged the showing that he made, and I think that goes exactly to this issue of his financial resources to satisfy a $148 million civil penalty.
If it's a post-judgment motion, though, I mean, it's not something that we can consider.
Well, the CFPB raised that issue to try to support the district court's determination that Mr. Wang still had access to substantial resources in order to satisfy this penalty. He's already turned over more than $10 million in assets, including considerable assets that were not the product of this scheme, which, according to Mr. Wang, he only received about $1.5 million. If I may have just one more minute to address a couple of the other issues. As far as that time period goes where Mr. Wang contends that he's not liable, the issue is what he knew and when he knew it. And that really comes down to the Mr. Kim's declaration versus Mr. Wang's 49-page declaration. And if you look at Mr. Kim's declaration and Mr. Nguyen's declaration carefully, you will see that there's really, and including the exhibits that supposedly support it, there's nothing in there prior to 2018 to show that Mr. Wen was actively involved in the operation. This was really Mr. Kim's enterprise. Mr. Wen became involved. He's not contesting that he would have become liable after June of 2017. But for that prior period, which is important in determining the amount of the civil penalty for sure, there are definitely issues of material fact. If the court doesn't have any other questions, I would submit.
All right, thank you, counsel.
Thank you very much, Your Honors.
The CFPB versus Wen is submitted, and I'm going to see if counsel for Wang versus Bondi is here. Yes, Your Honor. That's you, Mr. Badar, okay. Well, we'll take up Wang versus Bondi now. Mr. Badar, you may proceed.
Good morning, Your Honors.
Morning.
May it please the court. I am Conrad Gregory Badar. I'm here on behalf of the petitioner Tongxi Wang. Now, generally, this case is the petitioner's story of religious persecution by the Chinese authorities. But specifically, when we drill it down, this case is a compelling story of enforced religious deprivation. Now, what do I mean by that? What I mean is that in 2012, the petitioner was compelled to leave his home, his wife, his family, and his culture, principally on his account of enforced religious deprivation.
Can you address the credibility challenges, and how do you get over that?
I'm sorry, I have
Can-
a
can-
hearing impairment,
Oh,
I'm
no,
so
no.
sorry.
No, that's okay. Can you address the credibility finding and how you get over that?
Yes, I was going to do that. To be sure, when Tongxi Wang presented his testimony at his May 2016 evidentiary hearing, it was not a shining moment. His testimony did conflict with internally and with both of his declarations and his sister's affidavit and the other corroborating documentation of his household registration booklet. The
You're not
immigration
arguing, you're not arguing that the adverse credibility determination is not supported by substantial evidence?
for those limited portions, correct. As it relates to the petitioner's account of past persecution for those first 2 days, on the record, it appears that his inconsistent testimony does impact his credibility. However, what I want to focus on today are the strengths of the petitioner's testimony, namely that the petitioner did testify that he, as a condition of his release.
Oh, hold on. You're conceding that the credibility finding is correct as to, and that they are inconsistent as to those points. That you're conceding that right now.
As to the testimony as it relates
Do
to
you really
his,
want to concede this? I really am tired of petitioner's counsel coming here and conceding their petitioner's case. Let me ask you something. We've sent out numerous orders to you asking for responses in this case. It was closed for a while administratively. You haven't responded at all. The current motion that you filed
Right.
is a motion to dismiss petitioner's case. Is that zealously representing your client?
I am zealously advocating for my client's interest because that is what he has expressly authorized me to do.
Why?
Because he has earned lawful permanent residence since May of 2022.
Why haven't you filed any documentation to that effect? Why are we here?
Right, Your Honor. That's what I
Why
did in
didn't
my
you say this
motion.
for the first, he has lawful permanent residence now?
Yes, he does, since May of
Have
2022.
you filed any papers demonstrating that?
Yes, included as an exhibit in my motion to dismiss the PFR.
So if he has lawful permanent residence, which the agency grants through one hand of its operations, why is the other part of the agency trying to enforce a deportation order?
Yes, Your Honor. Months ago, I had related the same as I'm discussing right now to oil, and I was instructed to, by both the clerk and,
What clerk?
which clerk?
What clerk? Clerk of what?
Deputy clerk here?
Which clerk? What's the name?
Well, it's not Susan Gelmas, but someone before that. But Susan Gelmas knows what I did file, and she instructed me that I was not permitted to withdraw the petition, that the court wanted to hear remarks from the petitioner.
Have you filed anything to reopen in the BIA? I mean, to resolve this interagency conflict that Judge Wardlaw has identified? So have you filed anything in the BIA reflecting the lawful permanent status that your client now has?
What I did file was when the enforcement priorities were in effect with DHS, was a request to, for prosecutorial discretion on this matter.
But do you understand whether your client has a right to reopen the proceedings before the BIA given this change in conditions to address the underlying removal order?
I understood that I had to dismiss the matter here before I could.
In order to do it in the BIA, your understanding is that the BIA would not allow you to reopen before the dismissal of the matter here?
That has been my experience before.
Okay.
Wait, that's been your experience.
Yes.
But as to this case,
Not as to this case, Your Honor.
as to this case, I mean, that's why we were issuing all these orders for information from you, is because we saw that his wife had had her status adjusted. We could see that, but we can't see from the agency's administrative record evidence of the lawful permanent resident status of your client.
Included in the record as an exhibit is the I-730 approval. I also
But
forwarded.
we don't have the the administrative record from the agency as to that.
I hear the court's words, and I did not obtain the documentation that the court is.
But no, usually the agency provides it to us. Did they know? Did they know about?
They being the USCIS and I don't know.
Okay, why don't you reserve your 3 minutes?
I will reserve.
And maybe the agency can shed
Very
some
good.
light on this. Okay, great. Ms. Chang?
Good morning, Your Honors. May it please the Court. My name is Linda Chang, representing the U.S. Attorney General in this matter. Unfortunately, my office was also in the dark for most of this case regarding his adjustment to lawful permanent status. We learned about that on Friday, just a few days ago.
How did you learn about it?
I called through various channels within USCIS and finally got a hold of someone who could tell me this. However, I do not have the documentation for it. It was just a conversation that I had.
But it's true that
This is, yes, this is apparently true.
So are you going to withdraw the deportation order, or what?
So that deportation order is something that petitioner and the agency need to work out. At this point, we do not oppose his motion to withdraw the PFR in this court because his own asylum application is irrelevant as he has obtained legal status. So it is something that he needs to work out with the agency at this point, and this court is no longer or my office is also no longer playing any roles in his application for asylum because it is not needed. as
Well,
he already
if
has
that's the
obtained.
case, I mean, what's the agency's general practice now, and, to the extent you can speak to it, where there are now grounds that you concede that he's not removable, given the change in the status? Why is it up to the petitioner to do that when the agency, the executive, which we sometimes think of as unitary, has this information? Why can't it do something about it?
So this case is in a different and unique posture. Typically, when petitioners reach out to our office regarding the potential to adjust, they do have something that is pending before before USCIS as in terms of a benefit, and therefore we would have them request the board for a joint motion to reopen, or request a joint motion to reopen with DHS before the board, and then have it sent back down to be adjudicated before the immigration judge for the relief that they request. However, his relief has already been granted at this point, which is unique here, and
So
therefore,
are you arguing that this is moot?
yes.
But I guess what's puzzling to me, at least, is that this is in a category of cases that I understand have been held in kind of administrative abeyance for years. And it would have taken, as I understand it, the agency to take an affirmative step to reactivate this case, get us all involved in this, reactivate, was there never any, did one hand check with the other with respect to whether this case should be reactivated? I guess my concern is, given the number of cases that are in this status, and that, as I'm sure you well understand, that are quite stale now, as in this case, that the agency and oil would be seeking to reactivate cases without checking to see whether they were moot.
I understand your concern, Your Honor, but as I said, our office only knew that he had the approved 730, which he had filed in 2021 before we put this case into JAC. At that point, we thought he was going to do something with that. He did not tell us that any further progress had been made with that application, so we assumed that he was just still at a standstill. And so as we took it out of JAC, we thought that that would be something that we need to address with him or pursue or somehow figure out, but he never reached out.
Ms. Chang, might I recommend that oil place that call before it takes something off of the administrative stay so that we know that we have a case rather than after?
I do understand that frustration, Your Honor. However, again, this is, the information that you seek is within petitioner's hands. He has known since 2023 that he was an LPR. We were not notified that he was an LPR until
Who's
I
we?
reached out. Office of Immigration of Litigation, my office.
Litigation, oil didn't
Yes.
know, even though USCIS had granted the relief.
That is correct.
Certainly, I understand your predicament, but I also hope you understand at least my concern, particularly with all of these cases held in abeyance, that the I's are dotted and the T's are crossed to make sure that you still have a case before you ask us to renew our review of the petition.
Understood.
So what do you think we should do with this case? Because frankly, until I heard the argument, I was inclined to grant the petition, because I don't think the adverse credibility determination here is supported by substantial. This is just speaking for myself. So I don't know if he's better off if we could just go ahead and grant it, or if he's better off if we just dismiss it, or if the next step is you need to make a joint motion to reopen before the immigration agency to say, hey, he's a lawful permanent resident, so we can't deport him? Or, because we got to get the deportation order off the record, or his client could be deported, even though he has the right to remain in the United States.
That's right, Your Honor. So as I had said earlier, normally, while we have a petitioner who has pending relief, we would advise that they need to file a joint motion to reopen with DHS before the Board of Immigration Appeals and reopen, and then get it before the immigration judge to have their relief adjudicated. In this case, since he already has relief, we believe that this PFR can be withdrawn, as he has filed in his motion, or requested in his motion, because this PFR is moot at this point.
So you're saying grant the motion to withdraw?
That's correct.
That's not the same as saying that the order of removal is moot.
Not technically, no, Your Honor.
That's an important technicality.
That is something that petitioner would need to work out with agency at this point. Like I said, because his petition for review is no longer relevant to his obtaining status, I believe that my office and this court no longer have a role in his pursuit of that relief.
But it's still on the books with the agency.
That's correct.
You can see how that might be unsatisfactory in terms of full
I do.
relief here, given that we have a petition in front of us, and we may have concerns about whether the agency action is supported by substantial evidence, that we're relying on, we'll say, a complicated bureaucratic apparatus to ensure that the petitioner here is entitled to the relief that the government has granted him.
It's true.
So if we were to grant the petition and remand, that's in effect reopening the proceedings.
That would be reopening proceedings. However, you actually would be putting him back into proceedings, and the immigration judge might want to hear the case all over again, which actually puts him further back in his relief pursuit, rather than.
So maybe we should be asking, but why haven't you filed a joint motion to reopen yet?
That would be his request.
He needs to request it. So my understanding is when we first sent this when we first administratively closed it, it was for it to go to mediation.
Correct.
Because there was this, existence of the adjustment of status. So why didn't this come up in the course of mediation?
It came up in mediation that he was going to pursue this route, and he did not inform anyone in this courtroom that he actually achieved that.
You're right, that's true, including us, including the court.
Would that be worth, given the concerns about the state of the petition for review and the uncertainty about where this ends, would it be worth, and obviously this has been, the order has been around on the books for quite a while now, for us to hold off and allow the parties, before we act, to sort this out, before we relinquish our jurisdiction with respect to that order of removal?
That could be one option, Your Honor. But like I said, he already has his relief available, or relief obtained. He is an LPR at this point.
How about we send it back to mediation where it was, require the parties to mediate. He can show proof of his lawful permanent resident status, and you could jointly move to reopen at that point. Would that work?
That could work, Your Honor.
Okay.
Ms. Chang, again, I appreciate that you're in a spot, and I also appreciate your constructive answers to the questions. I understand that you don't know everything that's going on, and that we're all in the dark about something, so I appreciate your cooperation with my inquiries.
I think we all do, because we honestly didn't dismiss this case because we wanted to hear and attempt to sort out what's going on in this case.
I understand.
Okay, thank you so much. Mr. Bedar, do you object to being sent back to mediation?
No objection.
Okay. All right. I will not be submitting this case at this time. and we will issue the appropriate order after we discuss where we should go with this. Thank you, counsel. Okay, we'll take up Long versus Weeks. Mr. Roystacher? Roystacker? Okay. You may proceed.
Good morning. May it please the court, Lee Roystacker on behalf of the appellants. I'm going to reserve 5 minutes for rebuttal, and I will watch the clock. We're here today on an interlocutory appeal of the district court's order after remand denying the appellant's motion to dismiss on qualified immunity grounds. Based on the order that we got last week, I'm assuming the court would prefer me to start with the mootness issue as opposed to the merits.
That's correct. Thank you, counsel.
So, as the court knows, we asked for the opportunity to brief this issue, but we're here today, so let me say a couple things about at least our position on this. This issue was raised in the prior appeal and resolved. So that's the position that we believe is the correct one. The phallic case or flat case was cited and discussed and analyzed before, and the prior panel held that it must have held that it didn't control, and because it's factually distinct from the circumstances that happened here. And this, in our case, a notice of appeal was filed first, and then an amended complaint.
So, Mr. Roystacker, is your position that when the second amended complaint was reportedly filed in the district court here, the one that would otherwise moot our review of the first amended complaint, the district court had been deprived of jurisdiction at that point because of the notice of appeal, so that second amended complaint is not actually superseding the one on review?
At least with respect to the Section 1983 claims, because those were the ones that were on appeal. The second amended complaint had a Monell claim that wasn't automatically stayed because it wasn't part of the appeal. So it's a tricky,
Okay.
it's
More
a very
complicated
tricky
than that. Okay.
procedural sort of situation because of those two things. Like, so they had leave to amend to reallege Monell, not Section 1983, because the district court denied the motion on those
That
claims.
was denied, yes. Okay,
So
I see.
that's sort of the, and I'll acknowledge, I don't think phallic controls, but I'll acknowledge that there's no precedent from this court, at least dealing with the kind of sequential issue that we have here. I mean, there are out-of-circuit cases from the 7th and the 5th that are more closely aligned to our procedural posture.
What, if we were to affirm, it's not what you're asking us to do, but what's your view of what happens next in the district court?
Well, again, somewhat confusing and complex because there's a second amended complaint.
Part of which you would agree is still operative?
Yeah, the Monell claim, and we actually moved to dismiss that claim way back when. Everything got stayed when the appeal got filed. The district court stayed the entire case.
Well, I understand from, footnote 4 of the court's order that he's going to revisit that after the stay. That's what I understood.
That's correct. But then the rub is that the plaintiff has filed a motion for leave to file a third amended complaint.
Well, but that's addressed in the footnote indicating that they will consider that at that time.
Yeah, I guess the district court's probably gonna, I think the court's gonna consider all of those sort of pending motions at one time.
Do you want to move on to the merits?
Yeah, if there aren't any other questions about the mootness. Again, I acknowledge that sort of a tricky issue, and one of the reasons why we wanted to brief it, we recognize the sort of oddness of how this has played out.
Counsel, I have on my notes, procedural mess at the top of my,
I have
notes.
called it similar things, but perhaps worse. But yeah, it is a procedural mess. So I first want to start a little bit talking about qualified immunity because it sort of dovetails into where we believe the district court errors are. And then address a specific claim or two depending on the time I have left. So start from the proposition that an officer is entitled to qualified immunity unless the plaintiff pleads under the relevant Iqbal Twombly pleading standards a constitutional claim. Prong one. Prong two is that clearly established law existed at the time that is clear enough and particular enough that all reasonable officers would understand what they're doing at the time violated the law. A lot of ink has been spilled over the years on what exactly clearly established means, including in our briefing. We spent a lot of time on it. I'm not going to go over all of them.
well, specifically on fabrication of evidence, Long pleads that, and why isn't Pyle clearly established that?
On the fabrication?
Yes.
Well, Long pleads fabrication. I mean, she pleads that things were fabricated. But so you're sort of, I think, asking me two separate questions, at least as I see it. One is an adequate claim pled, and then number two, was there clearly established law?
Okay, so yes, she pleads fabrication of evidence. And don't we, in order to even review this, in order to even have jurisdiction over this question, don't we have to look at all the pleaded allegations in the light most favorable to the plaintiff, and then say, does it plausibly allege a violation, and then determine whether it was a clearly established right?
That's correct.
Because otherwise, we don't even have jurisdiction.
Well, that's why you have jurisdiction over the factual content, is because you can't get to the second question without first determining the first.
Right, so we have to take it all in the light most favorable to her, and she does plead fabrication of evidence.
Yeah, she pleads a circumstantial fabrication claim.
Right, I mean, which is circumstantial, doesn't add much to that, as you know, for lawyers, particularly at the pleading stage. And we also don't consider news reports or the other articles or some of the things you're relying on, right? That would be beyond, we wouldn't have jurisdiction to go beyond the four corners of the complaint.
Well, I don't think we're relying on anything outside the record, outside the complaint for the fabrication claims, other than perhaps the trial transcripts that show the existence of what people testified to, which is the same thing that the plaintiff is claiming was fabricated. But the fabrication claims aren't necessarily all bound up in any judicially noticeable material. The point to the fabrication claims is that what's alleged is coercive interviewing techniques on witnesses that somehow overcame their free will to tell what they wanted to tell, and that Weeks somehow coerced them into saying things that the witnesses themselves didn't think was true. So you have to look at, coercive is a conclusory statement. You have to look at what is alleged to demonstrate coercive conduct. And there's three witnesses, or one group of witnesses and two individuals that are alleged to be coerced. First is the neighborhood witnesses. If you look at what's alleged Weeks did with respect to neighborhood witnesses, you won't find anything because there's nothing alleged. It merely says coerced. If you look at Jeff Dills, the allegation is that Weeks threatened him with prosecution. And if you look at Oscar Castaneda, the alleged coercion is telling him he needed to alibi his girlfriend because Long was pointing the finger at him. Telling somebody that, or they're threatening somebody with prosecution or telling them they need to alibi somebody, that's not coercive. That is not conduct that is so coercive and over the top that the person wouldn't be able to exercise their free will and feel compelled to say something else that wasn't true.
Are you suggesting that our cases must clearly establish that those means of coercion are unconstitutional?
I am.
So I guess this is, I think, a theme throughout in terms of understanding the level of specificity. Don't we tend to require more specificity with respect to, most notably, with respect to excessive force claims, because in many ways they're snap judgments and they're very fact-specific. But on the middle run of qualified immunity claims and the underlying constitutional claims, for example, deliberate indifference with respect to 14th Amendment claims for deprivation of family relations, those sorts of things, we still do review it at a pretty high level. And I guess what I'm wondering is, what's your authority that we should take kind of that very specific excessive force, fact-specific snap judgment claim standard of specificity for qualified immunity and apply it in these kind of broader general due process questions?
I would say this. The specificity analysis is what the Supreme Court mandates. I mean, we've all seen that. The question is whether it applies to other rights other than the Fourth Amendment, and the answer is yes. I mean, this court has said that. In Rico versus Ducart, 980 F. 3rd at 1299, the court said the fact-specific, highly contextualized nature of the inquiry does not depend on which particular constitutional right a given plaintiff claims officials have violated. In Hamby, which was a number of years before, 821 F. 3rd at 1091, this court said, not only has the Supreme Court never suggested any such distinction, but several cases affirmatively repudiate it. And then it went on to cite several cases dealing with the First Amendment, the Eighth Amendment, First Amendment. So that's the answer to the question, I believe, is do we apply that highly specific, contextualized, factual analysis to 14th Amendment claims? And the answer, according to the court, is yes.
But we don't in other areas of 14th Amendment claims. I don't think we do with respect to equal protection claims. I don't think we do with respect to due process claims, again, alleging deliberate indifference or purpose to harm claims in excessive force cases.
Well, I think that it is done in 14th Amendment claims in excessive force cases. I don't have the cites with me because that's not one of the cases that, that's not an area that we're dealing with. But I don't think it's correct that this analysis is amendment driven or right driven. Because what happened, and what we have two problems with the district court's errors. One is that the district court determined that the law didn't have to be settled. Okay, that's in the order. We know that's not true. The Supreme Court has told us the law has to be settled. And the second one is nowhere in the district court's order, anywhere will you find an analysis of the allegations being made against my clients in the complaint and relating them to any facts of any of the underlying cases. And I think
You're arguing that there has to be a case squarely on point on the facts in the law.
well, I mean, I will concede that it's true that there doesn't have to be a case directly on point. But it's also true that close enough isn't good enough. I mean, the Supreme Court has said in White versus Pauley, essentially, we don't require a case directly on point, but existing precedent must have placed the statutory or constitutional question beyond debate.
But isn't it beyond the debate that the police officers cannot fabricate evidence in order to win a conviction?
As a general proposition, yes, I agree with that.
And wouldn't a reasonable police officer know that they're not supposed to make it up?
Correct, but there's no allegation that Weeks made anything up.
Oh,
The
there-
allegation is he coerced witnesses by doing A, B, and C.
To pursue a false prosecution.
Again, well, that's the allegation.
Right, but that's.
But there are no facts establishing any coercive conduct.
Okay, what about your time's up. Your time is up, but I just want to ask you, would you make the same argument with respect to the suppression of exculpatory evidence, that is the blood-free jacket belonging to Long, which was suppressed?
Well, I would, because that's what this case held in Korea.
That a well-known, well-established Brady violation?
Well, I don't think, I mean, I think the judicially noticeable material clearly establishes that blood-free jacket.
But we're not supposed to be looking at facts at this point and disputing facts.
But you can look at the trial transcripts.
We can look at that, but I mean, we can't take it as true.
Well, what you can see, though, what you can take as true is that the jacket was discussed, that testimony occurred, that event happened. You don't have to take the testimony as true.
I'm not sure we can do that. We're supposed to be looking at the four corners of the complaint at this
But
point.
if I might, on your question, I mean, Carrillo says exactly, even though it was clearly established at the time of the investigations that police officers were bound to disclose Brady evidence, we must next consider whether every reasonable police officer would have understood the specific evidence allegedly withheld was clearly subject to Brady's disclosure requirements. And the jacket's just one part of the claim. I mean, the main part of that claim deals with officers' opinions and conclusions. But I'm a minute 40 over my time.
Right.
I guess on my 10 minutes, so I still have some rebuttal time, I think.
Not really.
Not really? That was 15 minutes? Wow, that was fast.
Yeah, that was fast. I
Okay,
agree.
thank you.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Steve Art for the plaintiff appellee Kim Long. Kim Long was wrongly convicted of a murder she didn't commit and spent years in prison because of police misconduct. Long's pleadings explain in detail how each of the 5 defendant officers violated her clearly established constitutional rights when they fabricated false evidence, when they suppressed material exculpatory evidence, and when they failed to preserve exculpatory physical evidence in bad faith. The district court has correctly denied qualified immunity on the pleadings twice now, and if this court reaches the merits, it should affirm easily. Unfortunately, this court lacks appellate jurisdiction for 2 reasons. First, because the defendant's entire presentation of the appeal is a factual dispute about what is pleaded in this case, and this often by reference to outside materials. And this court lacks appellate jurisdiction in a collateral order appeal considering qualified immunity to consider factual disputes. Second, the appeal is moot because the order being appealed and all of defendant's arguments focused on a first amended complaint that is no longer operative in the case.
Why did the district court have jurisdiction to accept the filing of the second amended complaint to supersede the one on review?
So this court's precedents about transfer of jurisdiction during appeal suggest that if an amended complaint is filed during the pendency of an appeal, it moots the appeal. That's what Falk says. That's what the cases we cited earlier this week in our submission say. They talk about a complaint being filed during the pendency of an appeal. But even if you accepted the defendant's view that jurisdiction at the moment the notice of appeal was filed transferred to this court. When this court issued its mandate and the case was remanded, the second amended complaint was certainly operative at that point in time. The district court continued to adjudicate the pleadings. We filed a third amended complaint saying to the district court, you should consider this third amended complaint and make the decision about qualified immunity based on that complaint. The other side opposed that effort and said, no, don't accept the third amended complaint. Don't look at the second amended complaint, look at the first amended complaint. And that's how we ended up with a second decision denying qualified immunity.
Mr. Art, I guess I'll tell you a broader concern I have. I'm not sure whether this case is it. But qualified immunity is immunity from suit. And this case is a bit of a mess procedurally as it comes to us. So what's, under your theory, what's to prevent a plaintiff from essentially subjecting someone to unreviewable on appeal suit that in a way that doesn't allow us to reach the qualified immunity issue that a defendant is entitled to have us hear?
I mean, I think it absolutely needs to be considered at the earliest possible time, but in order to invoke this jurisdiction, a defendant who is appealing an order has to make sure of two things. One, that the order of the district court that is being appealed is a final order disposing of an operative complaint. And two, that when the case reaches this court,
Well, it doesn't have to be a final order for purposes of interlocutory appeal, right?
Well, Your Honor, I think the entire idea of the collateral order doctrine is it is considered final to the extent that the district court has resolved the legal question, is there qualified immunity based on the plaintiff's facts or the plaintiff's pleadings, right? So the notion is that this qualifies as a final order under 1291 under the collateral order doctrine. Okay. Even though it is interlocutory in nature, as Your Honor is saying.
But how do we know that? Must it always only arise from right, where it's a denial of a motion to dismiss? How can we tell?
I mean, in the typical, and in the cases that we have litigated, like Ms. Long's, usually you have one order in the district court where there is a opinion saying, here is the denial of qualified immunity, and that order is appealed from, and the defendants on appeal say, we will assume the truth of the plaintiff's facts, and clearly established law has not been violated. That is the normal course that happens in the extreme majority of these cases and allows the qualified immunity question, to Your Honor's concern, to be resolved at the first stage of the case. That hasn't happened here.
But that hasn't happened because you filed a second complaint.
We were ordered to do so by the district court. So the district court in December 2022 denied the motion to dismiss the First Amendment complaint based on qualified immunity, and at the same time ordered us to file a Second Amendment complaint, which we did on schedule. We filed that Second Amendment complaint about 3 weeks after the first notice of appeal was filed. We argued in the first appeal that mooted it and the court should dismiss the appeal. We filed a motion to dismiss and send it back for resolution of the qualified immunity issue on one complaint. The court looked past that mootness issue, reached the merits, remanded for further consideration of qualified immunity. At that point in time, we moved to file a third amended complaint to prevent this issue, right? So that there wasn't a decision being made on a defunct complaint. The defendant said, no, please decide based on the first amended complaint, and that's why we have another appeal from an order.
You're asking us to send this back down, resulting in a third appeal on qualified immunity on that third complaint.
If the court asks me what I think of the jurisdictional question in this case, I unfortunately think there is no jurisdiction. I want nothing more than an opinion on the merits affirming the denial of qualified immunity. The case has been delayed at the pleading stage for 4 years, almost 4 years. We haven't done any discovery. That is extraordinarily prejudicial to my client, Ms. Long. Witnesses' memories fade, witnesses pass away. So of course we want this resolved. I would submit to the court that where a defendant does not follow the rules to obtain this court's jurisdiction, right, both by not making sure that they're appealing from an appealable order and by in each of the appeals in this court saying to this court, we're going to contest all of the facts. I mean, to be clear about the factual challenges, they start their brief by saying Long's suppression of evidence theory relating to the jacket is quote unquote untrue. And so we're not even going to discuss it. They contest whether they suppressed evidence, what their mental state was, Whether they fabricated it.
You're asking us to, it sounds like, I think you were asking us in your briefs at least, to dismiss the appeal for lack of jurisdiction. Isn't the better approach, and one we've taken, to simply disregard the factual disputes and decide what's on the complaint?
So our view of that is that the defendants appealing an order that is not final are obligated to secure this court's jurisdiction by affirmatively agreeing that the plaintiff's facts are true and arguing there is no violation of clearly established law based on those facts. When the appealing party does not do that and instead contests the facts as a way of saying that the law is not clearly established, this court should hold that line and say a litigant in that posture has not done what it needs to do to satisfy the collateral order doctrine and to appeal a final and appealable issue under 1291. And the reason is because otherwise you get appeals like this in succession in constitutional cases where the issue is not, is this court's and the Supreme Court's law clearly established, but instead, can the court consider some sort of factual dispute?
What do you think is the most speedy way to get this case resolved?
Our sort of ideal opinion, given the jurisdictional issues in the case, is to dismiss this appeal for lack of jurisdiction because the order appealed from is not operative and the appeal is moot, and because the defendants raised nothing but factual contests to the allegations, and to hold, Your Honor, that a third appeal should not be permitted at the pleading stage of this case. The Supreme Court in Barron's made very clear a qualified immunity appeal may be appropriate both at the motion to dismiss stage of the case and at the summary judgment stage of the case. But the Supreme Court, in that opinion, discussed the concern about cases precisely like this one, where there are repeated appeals at one stage of the case. And in this case, we think...
Just ask you, why do you continue to file amended complaints then? Why don't you just go with the first one?
I wish that I had, Your Honor, to be frank. Our situation is we were ordered to file a second amended complaint, and so we followed that order and we did that. And then we asked the question, what jurisdictional effect does this have? And I think that the answer to that, in candor, is that it deprives the appellate court of jurisdiction because that first amended complaint and the decisions disposing of it are not operative. And so, that is my frank answer. And then on remand, what I thought to myself was, I better file a third amended complaint here to clean up all the allegations, put them in one place, and give the district court a single complaint on which it can evaluate qualified immunity. So the next time we go up an appeal, the court will have a final order that it can consider qualified immunity on with all of our allegations. And I advocated that in the district court. I said, please accept our third amended complaint. The defendant said, no, don't. You should make this judgment on the first amended complaint. And we ended up in this, and the district court agreed with the defendants and said, I'm not going to accept the third amended complaint. I'm going to decide it based on the first amended complaint. And here we are in this situation again.
Had the same district court judge throughout this?
The complaint was initially filed in front of a different judge who dismissed it.
Right, because Judge Slaughter was recently appointed.
Correct, Your Honor.
And he came on and he inherited this case.
Right, so he inherited it at the first amended complaint, ordered the filing of the second amended complaint, and didn't accept the third amended complaint on remand. And so, we think that this case should be dismissed for lack of jurisdiction with an order that says to the defendants, you cannot appeal a third time at the pleading stage. On the merits, this is not a close case if you look at our pleadings. This case pleads very deeply established constitutional claims. To address the court's questions about the level of specificity, this court in the Carrillo case and in the Tennyson case has made very clear that when the right in question is the right to exculpatory or impeachment evidence or the right not to be tried at a trial based on fabricated evidence, because the constitutional prescription is much more specific, you don't need a case exactly on point about precisely the type of evidence in question as you do in the Fourth Amendment context.
Mr. Art, do we have enough to go on, thinking of paragraph 40 of the complaint, that I guess about when the defendants allegedly decided to frame as long, It's quite abstract. It doesn't tell us whether it's before or after certain acts. It just says defendant settled and built a case against her, but it doesn't give us any specificity about when they might have done that. Is that enough to go on?
Maybe not on that paragraph alone, but drawing inferences from what is pleaded across the complaint. The allegation is that Long was selected as a suspect at the very moment that the 5 responding officers who are defendants in this case appeared at her house. And at that moment, they decided that she would be their suspect, and that caused them to do several things. It caused them not to collect the blood-free jacket as evidence, and to make a report that that jacket had been discovered that way and suppress that report throughout criminal proceedings. It caused them not to collect DNA and fingerprint evidence from the scene. And it caused them immediately, really in the first 24 hours, Defendant Weeks fabricated a story for Jeff Dills to tell, which was of profound effect in this case. And my colleague says that we don't allege that there was actual direct fabrication of evidence. We allege it was coercion. Not so. What we're alleging is that Dills, who was with Long during the crime at issue and who dropped her off at her house minutes before 2:09 a.m. when she called 911, we allege that Dill told Weeks at the start the same story that Long had. Weeks was her only alibi witness, and instead of accepting that story, Weeks fabricated an account where Dills had dropped Long off 40 minutes earlier, creating the opportunity for her to commit the crime. And as every single court who has reviewed this case in the criminal and post-conviction proceedings has recognized, Dills' testimony creating that opportunity for Long to commit the crime was profoundly important in this case. And so the allegation is not that he coerced Dills. He certainly did. The allegation is Dills told him story A, and he said, no, Dills, you're gonna tell story X. And that is direct fabrication of evidence. It is clearly prohibited by this court's decisions, including in Spencer against Peters. It shows that the police and the witnesses who are key in this case were lying. This court in Mellon made very, very clear that where investigating officers know that a witness has lied, it must disclose that evidence. And so the claims in this case are clearly established as unconstitutional. And if this court does not dismiss the case for lack of jurisdiction and hold that the defendants here cannot take a third appeal at the pleading stage, the court should affirm all the denial of qualified immunity on the constitutional claims.
All right, thank you, counsel.
Thank you, Your Honor.
Long versus Weeks will be submitted. This court will be in recess for the next 5 minutes so that the counsel for the next case can get settled, and then we will return. Thank you.
All rise. This court stands in recess for 5 minutes. All rise. This court now resumes its session. Please be seated.
All right, we will now take up National TPS Alliance versus Kristi Noem and the Department of Homeland Security. You may proceed, counsel.
Good morning. May it please the court, Drew Ensign, Deputy Assistant Attorney General for the United States. I'd like to reserve 4 minutes for rebuttal.
Yes, and please watch your clock.
Thank you, Your Honor. As the Supreme Court has already implicitly recognized by an exceptionally lopsided vote, the government is likely to prevail on appeal here, either in this court or, if necessary, in the Supreme Court. This court should follow the Supreme Court's lead and reverse. This case should begin and end with jurisdiction. Congress has gone out of its way to enact an exceptionally broad prohibition on judicial review, providing that, quote, there is no judicial review of any determination of the Secretary with respect to the designation or termination or designation or extension of a designation of a foreign state under the subsection, end quote. The language has two features that make it particularly broad. First, it employs the adjective any to modify determination. And second, it applies to any determination, quote, with respect to the designation or termination or extension, end quote, and not merely terminations and extensions themselves. This language is exceptionally similar to Patel versus Garland, which held that a statute barring review of, quote, any judgment regarding the granting of relief, end quote, covered, quote, any authoritative decision, end quote, on the matter. Similarly, this court's decision in Reeb versus Thomas that Congress' exclusion of APA review of, quote, any determination, decision, or order, end quote, of the Bureau of Prisons barred review even in the habeas corpus context. So here, the Secretary's vacator of Secretary Mayorkas's 11th hour extension of TPS status falls squarely within Congress's prohibition of judicial review. It was a, quote, determination, with respect to, an extension, end quote, of TPS status. It is squarely within the heartland of the jurisdictional bar that Congress has enacted.
So what couldn't the Secretary do with respect to that? You concede the vacators nowhere in this statute. So any determination with respect, if this is a determination with respect to an extension, what isn't?
I mean, certainly this is very broad language. And just to be clear, I don't think we concede that vacator isn't in the statute. We think it's implicit in the grant of authority.
We'll be textualist for a second. In the text of the statute.
Your Honor, I think the effect of the text of the statute when combined with background principles.
Understood. Okay.
Thank you, Your Honor. Your Honor, it is exactly as Congress intended, anything with respect to a determination. Now, there may be edge cases. The Supreme Court does have the Kine doctrine that is recognized and reiterated a couple years ago, where something is extraordinarily and like blatantly ultra vires. Sometimes you can get judicial review even in the teeth of a prohibition.
Let's have an example of a determination that grants perpetual protected status.
Your Honor, I think that potentially could fall within the Kine exception, but notably here, plaintiffs have not attempted to invoke or to even acknowledge that doctrine. But the Supreme Court has devised that sort of safety valve for extraordinary cases like that. But we're not only not here, it's not even being argued here. And more generally, when Congress enacts a very broad prohibition on judicial review, that's Congress's determination that these matters are reserved to the political branches. If the executive does something that is beyond the pale, such as like a perpetual extension, Congress recognizes that they can certainly step in to correct that.
But
I'm sorry.
No, go ahead.
Isn't the first claim alleged that the Secretary overstepped her statutory authorization by vacating a prior grant of TPS?
Yes, that is the nature of their claim, but that is not the sort of thing that would fall within Kine. Kine is the sort of more like what Judge Johnstone was referring to, where it says you can only grant an extension for up to 18 months and you grant one that's perpetual. It has to be something that is egregious and, beyond the pale. And again, plaintiffs have not even attempted to invoke
But
such an
this is
exception.
just the other side of this infinite spectrum. The Secretary is essentially saying that it's granted for 0 days.
I don't believe so, Your Honor, for a couple of reasons. I mean, I think what we have here is you have a background principle of administrative law that everyone acknowledges that as a general matter, agencies have authority to reconsider their decisions as long as they do so in a timely manner. And timeliness is not remotely contested here or frankly contestable. So what you have is a disputed inference about text, which is not the sort of patently ultra-virus. It is an ordinary dispute about agency authority, where even they admit that, two things that I think are interesting. On page 39 of their brief, they say, no doubt the Secretary has authority to correct inadvertent ministerial errors. So they're already admitting that the Secretary has some authority to reconsider.
Is this an inadvertent or ministerial error? It seems like it's not.
No, Your Honor, but I think that concession is important because it recognizes the existence of some authority, and we're just fighting about the extent of it. That is
Franzine, why wouldn't the existing authority lead us to the same place as at least where we landed in the Ramos case? I understand it's vacated, but working with the same sources, it seems like the line that they drew would have placed this on the side of reviewable.
Your Honor, I don't think so, and as obviously as you've acknowledged that it is not binding authority, but the Ramos case did acknowledge the authority to do this, and it also said that, recognized that that it precludes direct review of the Secretary's country-specific TPS determinations.
But if the Secretary exceeds the statute but only does it once, why does that make it a country-specific determination?
Because it's a determination with respect to one country.
But the fact that it was vacated, presumably is a power that could be exercised with respect to anyone. It wasn't vacated because, even with respect to the vacator notice itself, it wasn't vacated because of anything about Venezuela.
I think that's correct as to the vacator, the rationale is given. But
If the Secretary loses on vacator, we don't need to reach the terminations, right?
Your Honor, let me clarify that
Okay.
first thing and then circle back to it.
I thought you might. Go ahead.
It is very country-specific in that what Secretary Mayorkas did was incredibly country-specific. It revolves around Venezuela and nothing else, and this is a vacator of it. I don't think there's any reasonable way to understand the vacator of a country-specific decision as itself being anything other than country-specific.
It was country-specific, your argument is, it was country-specific because of the consolidation and realignment of the registration process. That was only, because it was merging in some ways these two Venezuela TPS determinations.
I think that's part of it, Your Honor, but just more simply, it's country-specific because it is specific to one country. I mean, that's.
So the Secretary gets one bite at the apple, or a mulligan with respect to exceeding the statute, but if it applied to more than one country, then we might be talking about jurisdiction.
Your Honor, we certainly disagree with what Ramos held, but I think that Ramos did recognize some room for the sort of programmatic and more overarching challenges. I think that, we think that's wrongly decided, but we also don't think that's necessarily to reach here because this is a country-specific determination. And in that way, it's also, unlike McNary, it is not a programmatic challenge. It is a challenge to a specific country one. It is directly within the heartland of what Congress has prohibited. Again, it is quite literally a determination with respect to an extension. That is the exact language that Congress used. That's why it's prohibited. I think that's why the Supreme Court was so lopsided in its vote. I mean, that's, of course, we don't know definitively what merits grounds they reached, but I suspect that was not in a small part of why.
Well, this may be a good segue then to something the Supreme Court had said earlier, that it's important that we receive genuine justifications for important decisions, in this case from an agency. And so as we look at the the justifications, again, on the second APA challenge. The terminations contain some, purport to contain national security, or maybe not national security, but public safety justifications. And I'm just wondering, given the seriousness of that, whether the administration has moved to exercise its power to withdraw TPS status from anyone, which is an alternative it can take if it's worried about the public safety threat that particular TPS recipients may pose.
Your Honor, I don't know specifically if they've tried to do so in individual instances. This is obviously a programmatic challenge. I wouldn't be surprised if they have done so, but candidly, I don't know.
Do you concede that under the statute, and then under 8 CFR 2414, that the Secretary can withdraw on an individual basis, even with respect to admissibility grounds that arise after the grant of status?
That is an additional tool that Congress has specifically provided to the Secretary that is not to the exclusion of her authority.
Well, then how does that bear on whether the Secretary's action was arbitrary or capricious, or whether the justification was sufficient, if we don't even know whether the Secretary has exercised pre-existing authority to address particular public safety threats posed by recipients of TPS?
Several responses to that, Your Honor. I think, first of all, given that the numbers involved here, there's not really an intersection between individual determinations and an overarching program. There's no suggestion that the Secretary could exercise her discretion in hundreds of thousands of cases in a way that would somehow supplant or render a feasible alternative what is, in fact, a duty imposed on her by Congress. It is not merely that she may terminate TPS status when it no longer meets the statutory requirements. Congress commanded that she shall terminate it. So even that existence of alien-specific authority does nothing to either diminish her authority or the congressional command.
Can you point me to the statute and specifically the language that you're indicating that gives the Secretary the authority to terminate a prior designation of TPS status? What specific language to the statute are you pointing to?
We're not pointing to specific language, Your Honor. It is a bedrock and well-established principle of administrative law that this court has recognized in CUA, and essentially every circuit court has recognized in a very long string cite we've provided. The courts have inherent authority to reconsider, or sorry, not courts, that agencies, forgive me, have inherent authority to reconsider their decisions as long as it's done in a timely manner.
But when Congress has specifically limited the time period of the kinds of designations and the extensions that can be provided, doesn't that counter your argument? Here, Congress has specifically said, hey, we will give you this authority for this period of time, and really only this period of time. Your argument is like, no, we still have, the Secretary still has the authority to change what Congress's grant is.
Your Honor, I don't believe so. While the statute does provide a mechanism for termination, it does not speak to vacator whatsoever. And indeed, I believe there's a concession in their answering brief that the statute is silent as to vacator. And where a statute is silent on the matter, the default principle of administrative law kicks in, and the agency retains its authority to reconsider decisions as long as it's done so in a timely manner. And again, timeliness is not challenged.
Why isn't this, I mean, I think that, isn't that a statute-specific inquiry?
Your Honor, it is a default principle that then turns on a statute-specific inquiry to see if an exception to that default principle would apply.
And we have, as I understand it, this statute was enacted against a backdrop of congressional concern about the executive's, about the executive having too much discretion with respect to both the selection of deferred enforcement and other executive actions, as well as the duration of those.
Your Honor, I disagree with that premise for two reasons. First of all, this was enacted against a backdrop that, as the D.C. Circuit recognized, that previous sorts of discretion for temporary status was unreviewable under the APA, and Congress enacted against that backdrop this very specific jurisdiction stripping statute. So I don't
Counsel,
think...
has any administration ever, since the enactment of the statute, done exactly what this administration done, which is take away a prior designation of TPS status?
Not specifically, Your Honor, but the prior administration did in fact exercise reconsideration authority to vacate a prior cancellation of status. And I think that's important too, because as my second answer to Judge Johnstone's question was, the statute is fundamentally different in a second way. It constrains discretion, but it does so in a very specific way. It says that
Just to be clear, the answer is no. It's never happened before.
Your Honor, know that we've never, the reconsideration authority has been exercised before. No, it has not been exercised in this specific manner before.
Thank you.
But it absolutely has been exercised before.
And a week after, so the timeline here is troubling, because Secretary Mayorkas extended the 2023 designation and consolidated 2021 and 2023 on January 17, 2025. And the new secretary, I don't know when she was even confirmed, but took action to revoke that about 2 weeks later. How can the country conditions have changed so drastically in that 2-week period?
Your Honor,
Could the review by the new administration have been done so quickly?
I guess several responses to that, Your Honor. First of all, as Justice Rehnquist's concurrence in the State Farm case recognizes, administrations have different priorities and they are allowed to weigh evidence differently. As to the specific—
Have to give reasoned explanation for their change in position.
Yes, Your Honor, and I think it's important on that arbitrary and capricious claim, because I think what's particularly notable is that the Secretary gave many reasons, and the district court, neither the district court nor appellee's answering brief even touches one which would be fully sufficient to justify the vacator. Specifically, Secretary Noem explained that the explanation for the operative impacts of the extension was, quote, thin and inadequately developed, end quote, and that vacator was warranted to untangle the confusion. The district court never addressed that specific rationale that the prior explanation was thin and inadequately developed, and you will also not find any discussion of that in the answering brief.
But if that were grounds for the invalidity of Secretary Mayorkas's extension, could not someone sue and change? I mean, in other words, you're suggesting it was something like arbitrary and capricious or otherwise didn't comply with the statute. The legal merits of it, and I think this is one of the teachings of the Supreme Court's decision in the Regent's case, is let that be litigated. If it's a legal concern, have the lawyers deal with it. But what you can't do is disguise that as a policy reason when there's not otherwise authorization to do so.
Well, I think a couple of responses to that, Your Honor. I mean, generally, you could litigate it, and of course, there's a specific jurisdictional bar here. But second, they have attempted to litigate it, but they haven't attacked that rationale as pretextual. You can't ignore entire independent bases for what the Secretary does and then say, we won on an arbitrary and capricious challenge.
Well,
but
you know, the other troubling aspect of this, and I think it's worth mentioning, the statements by the Secretary, and frankly by the President, but statements by the Secretary saying specifically the Venezuelans purposely emptied out their prisons, emptied out their mental health facilities, and sent them here. Don't these seem to be, and I'm not going to get into all the different other statements that were made that arguably are racist, not only by her, but by the administration, what do we do with those statements? What do we do with, in terms of this decision to have been done about 2 weeks after they came in?
Your Honor, I think what you should do with them is approach them as the Supreme Court did in the Trump versus Hawaii case, where they are, made prior to when people are in office or are remote in context from the decision at issue. They are not, they do not control the equal protection analysis. That's precisely how the Supreme Court addressed that in Trump versus Hawaii. The vast majority of Secretary Noem's statements refer to before she was in office. I believe all of the statements of President President Trump refer to it when he was either campaigning or when he was in office in the first time, which is, very remote in time. And so I think you should approach them as the Supreme Court has directed lower courts to approach them, that those sorts of statements do not make out a equal protection claim. And I think, more than just that, I think only rational basis review here applies. I think that also comes out of the Hawaii case. And I think that comes out, not just the Hawaii case, but in particular, I direct the court to Hawaii, Matthews, Mandel, and Harasides. I think all of those cases are very important to establish why rational basis review applies here. My friend has given two other reasons why it shouldn't, and I think both of them do not apply. The first is that they say that rational basis shouldn't apply for aliens already in the United States, but the Hawaii court already rejected that by citing to the Matthews case, where it was an equal protection clause challenge to people already in the United States, and so doing, it recognized that rational basis applied to that.
Mr. Enzine,
Yes.
I guess even under rational basis, if animus were the rationale for the action, it would still render it constitutionally suspect. I take your briefs to disavow any such purposes of the Secretary's action here.
We certainly disavow and deny any sort of animus. We also don't think that those statements are relevant to the right inquiry. As the Supreme Court made clear in the Hawaii case, the relevant question is whether there is it's facially legitimate and bona fide reason, and you look to the document itself, and where that inquiry is satisfied, as it was in the Hawaii case, that's the end of the equal protection analysis. Finally, just on rational basis, if I could, this court also has binding precedent on this, and I'm going to butcher the name of this, but the Manaskis case says that when challenged under equal protection, line drawing decisions made by Congress or the President in the context of immigration and naturalization must be upheld if they are rationally related to a legitimate government purpose. We also cited two other cases to the same effect. So for all of those reasons, we think the rational basis applies. The Supreme Court.
But how do we get around our Regent's decision that I guess we can debate whether it's law or not, but I believe that we've suggested that Arlington Heights is the appropriate standard to review claims of animus in making immigration policy?
Your Honor, I disagree for two reasons. First of all, in Regents, they merely assumed that the Arlington Heights standard applied and held that plaintiff's evidence failed under it. That's not a holding that it did apply. It's simply essentially sidestepping of, like, even if you think the more rigorous standard applies, your evidence isn't good enough, so we don't need to resolve that question. And second, the Supreme Court, relied on the Matthews case, which rejected, it did involve an animus claim below by the district court, and it nonetheless applied the rational basis review in Matthews, and then that was again cited as favorable authority in Hawaii, and in any case remains good law of the Supreme Court. Thank you, Your Honors.
Counsel?
Good morning, Your Honors. Ahilan Arulanandam from the UCLA Center for Immigration Law and Policy for Plaintiff National TPS Alliance and the individual plaintiffs. I'm certainly prepared to talk about jurisdiction and also appellate jurisdiction, but I feel obligated to begin by correcting the statements that were just made about the context of the Secretary's statements of animus that Judge Mendoza was talking about. The vacatur happens 3 days after she comes into office, and the next day she goes on Fox News to give an exclusive interview, and she says, she calls the Venezuelan refugee community as a whole dirtbags. Okay, 3 days after that, she issues the termination. And that's an interview where she's explaining to the public the reasons for the decision that just happened. If you look at the context, this is docket 67-1. You can see we have a chart that lays this out. It's very clear that she's talking about that decision, explaining it, and this is what she says. 3 days later, the termination happens, not a very long time, Your Honor, and she goes again on Meet the Press to talk about this. And she says, I'm quoting now, the TPP program has been abused, and then she talks about the connections to gang activity, and then she says, remember, Venezuela purposely emptied prisons and mental health facilities and sent them to the US, so we are ending that extension of that program. So it's the justification given to the public for this decision the day after the decision was made. And what the district court found, based on a mountain of evidence that we presented uncontested, is that there is a fact.
Their point is, we shouldn't consider that. Their point that she wasn't in office, I think, at the time.
Yeah, that's wrong, Your Honor. This is after she's made the decision. It's the day after she made the termination decision when she went on TV to explain it. And that's why they keep saying remote in time, and I don't know what they're talking about. There are 3 statements. There's these 2. The other one, which is also very clear expression of animus, happens in her congressional testimony. It's before she's confirmed, but it's 10 days before she's confirmed. And she's talking about the extension of TPS for Venezuela. And she says the extension of TPS for these 600,000 people, Venezuelans, is alarming because, and then she talks about this gang activity in Colorado that may be harming people. And you know what the district court found, undisputed in the record, is that there's no evidence that any TPS holders were in Colorado. The Colorado issue itself has been debunked. There's just a few incidents we're talking about, and this is why the district court found that this is the classic example of racism. It's taking a negative stereotype about a small number of people and generalizing it across the entire community. And so to claim that this is remote in time or that these statements are unconnected to the actual performance of the duties is just completely false. And
Mr. Alden, do we have to reach the equal protection issues
No,
if we rule in your favor on either of the APA claims?
No, absolutely you're not, Your Honor, and I'm happy to flip back over and start talking
I wonder
about
whether you have any more information than your friend did with respect to the withdrawal authority. So at least as to the second claim, where we're looking to see whether there's any other options to address with the agency's policy concerns. Do you also agree that there is individual withdrawal authority for anyone the Secretary determines, in fact, is now inadmissible?
Yes, Your Honor, that authority is clearly in the statute to withdraw TPS on an individualized basis if there's a finding that the person either is a national security threat or if they've committed even 2 misdemeanors or a single felony.
Are you aware of that authority being exercised at all by the administration?
In a couple of cases, Your Honor.
Okay.
So I know in some of the cases that came out of the AEA, the Alien Enemies Act invocation, and there were detentions of people. I litigated a couple of them, but you know, the ones I know about is like 2 or 3 cases.
But with respect to beneficiaries of the Venezuela TPS?
Yes, Your Honor.
So that authority is there and can be used?
It is, Your Honor. And I think this speaks also to the point, and I will talk about the APA claim, but just, you know, sort of connecting the dots here. The statute allows for individualized determinations that someone presents a national security threat or has engaged in criminal activity. It quickly renders them ineligible because, as I said, a single felony or 2 misdemeanors renders you ineligible for TPS. And that makes sense if there's an individual person who has engaged in activity that's not criminal or not protected the security of the United States, and there can be an individualized withdrawal. It's very different to do it for 600,000 people.
Can you address the APA claim arguing that that what was done here exceeded the authority of the Secretary?
Yes, Your Honor. So should I start with the jurisdictional aspect of that? Now they seem to be arguing that there's sort of an implicit beyond the pale exception. If there is such an exception on their own account, I would argue that we fit it because, as Your Honor said, in the 35-year history of the TPS statute, there has never before been a vacatur of a TPS extension. And also, you were asking about the statutory authority that this appears to violate. If you look at subsection B3B of the statute, it clearly states that a termination shall not be effective earlier than either 60 days before the notice or, if later, the expiration of the most recent previous extension under subparagraph C. So what the statute makes clear is that once an extension has been granted, it has to last for the whole time of the extension.
Well, your opposing counsel makes the argument that the administration, a new administration has the right to come in and change the policies of the prior administration. How does that apply here?
I think whether or not an agency has such authority is always a product of the statutory framework itself. Agencies aren't given, authority sort of by some magical common law. All agencies are creatures of statute, magical common law in this context. They're creatures of statute, and that's, the case law is very clear about this. So you have to look at the statutory scheme under China Unicom, under Gorbach v. Reno, and similar Supreme Court cases.
Well, they argue
to
that,
see-
sometimes there are these mistakes that are made within the agencies, and then that you have conceded that if they have that authority, why wouldn't they have this particular authority?
Yes, the distinction between clerical errors or ministerial errors and policy preferences is very long-standing in the APA law. It goes all the way back to American trucking in 1958 and has been repeatedly recognized. So on the one hand, even if there's no other rescission or vacatur or revocation authority, there's authority to correct typos. You cite the wrong provision, you put the wrong date. And it's a factual question whether such a mistake has occurred, and that can be litigated. That's always available because mistakes happen, and of course agencies to function have to be able to correct accidents. On the other end of the spectrum is policy disagreement, exactly what Judge Wardlaw was mentioning. They say, oh, well, we don't like what they did. We want to do it differently. And that is not always given. Whether or not that authority exists or not is a function of the statutory scheme, and this is a scheme that was designed to give stability to some amount of certainty for refugees in the face of the pre-existing regime, which allowed entirely unreviewable discretion. And so when he says—
Do you understand the, in these proceedings or elsewhere, and I asked your friend about this too, any kind of legal errors or APA irregularities that have been assigned to Secretary Mayorkas's decision? There's been a lot of, discussion about, there's this question about, well, maybe they didn't line up or anything, but has there been any allegation that that determination was illegal, contrary to law?
Yeah, no, Your Honor, and I want to talk about that 21-23 consolidation issue in a moment, but to answer your question, no, they sort of gesture at it, it might be illegal, but they don't just come out and say that determination was legal error. And of course, if they did, then that would be reviewable. It would be a legal conclusion of the agency that would itself be reviewable under very long-standing doctrine, just like statutory authority claims are reviewable. But they don't say that. The other thing I'll just say quickly, since we're on the subject of that consolidation, Your Honor, the Secretary's conclusion that there might be something unlawful about grouping together the 21 and 23 cohorts reflects a very basic misunderstanding about how TPS works. Of course, you can have designations that come into place at different periods of time, but the designation is for a single country. Venezuela was designated, and to qualify for TPS under the 2023 designation, you have to have been continuously present in the country and also residing here on a particular date in 2023. I think it was July 31st, 2023 and October 2023. Now, the people in the 21 cohort, well, they had to be in the U.S. and continuously residing since some date in 21. I think it was March of 2021.
So they're the same group of people.
Yeah, so by definition, everybody who is eligible under 21 is also eligible under 23, because if you've been here since 21, you've necessarily been here since 23. You can't have left. And so this basic misunderstanding of the Secretary about how the TPS statute works is highly relevant to the APA question. When he says, oh, well, maybe there were some reasons that were unlawful, but there were other reasons that were okay and we're disregarding them, that's not how APA doctrine works. Right? Under SEC v. Chainery, you look at the reasons that the agency actually gave, and if there are some reasons that are unlawful, then you reverse it. That's the sort of basic doctrine. Even the other reason that the Secretary gave, and so I realize we're now on the second APA claim, right? We're talking about the second APA claim, right? The other reason that the Secretary gave, which was that there may have been confusion caused by the consolidation of registration processes, and the district court found as a factual matter, and this is excerpts of record 56 to 60, there's 4 pages on this claim. Right? The district court found as a factual matter that rationale was pretextual. And if you look, and now we've got more administrative records, so this will, I assume, be coming here, in some months or something. But there's not a drop of evidence that there was confusion caused by this. And it makes no sense, because 2 tracks is more confusing than 1.
Why doesn't that cross the line, at least, again, we'll just
The jurisdiction.
sketch the line out with respect to Ramos, if that's a line. Why wouldn't that cross the line that Ramos drew?
Yeah, if that were about country conditions, if we were making that kind of claim about country conditions, it might well be on the other side of the vacated panel majority line in Ramos. But that argument concerns the registration processes and the consolidation of registration processes, right? That's what we're saying, that the reasons that were given as to registration are not correct. And registration is not addressed in subsection B of the TPS statute. Subsection B is all about the rules for designation, extension, or termination. And then subsection C is about how the agency then provides the benefit to people once it's given a TPS extension. So that's about who's eligible, what the registration processes are. You'll see registration is specifically there in subsection C. And that matters, Your Honor, because the stripping provision is only with respect to claims under this subsection, which is subsection B. It bars review of any determination as to a designation, extension, or termination with respect to this, or I've got the word slightly wrong, but under this subsection, and that is subsection B. So claims that have to do with country conditions, like asylum cases that you all hear all the time, right? We can't come here and say, oh, Venezuela is still oppressive. Venezuela is still in massive economic crisis and still it's still not safe to accept the return of its nationals. Our clients would very much like us to make that claim. It's undoubtedly true, but we cannot make that claim because that claim is barred. But what's not barred is a claim that the reasons that they gave having to do with registration are arbitrary and capricious, or that they failed to consider alternatives under regions. You know, the other thing is, if this is really true, that there was some confusion, which there is not, but if that were actually true, then they could just deconsolidate the registration processes and make the 21 people do 21 and give the 23 people a different date. But of course, they didn't do that. It was just a pretext to get rid of the entire
What about their
extension.
argument that they just made today about, oh, well, you know, the Supreme Court just, you know, lickety-split stayed the order. We should just put our hands down and say, you know, reverse.
Yeah, I have a few thoughts on that, Your Honor. The first is that that the order itself says that it will expire upon somebody seeking cert, or you know, if they grant it from an appeal of this, or the appeal that we're arguing right now. So if the court thought that there was no way to affirm the district court, then this whole proceeding would be a sham and make no sense. So that obviously can't be what they contemplated. What they contemplate is the case will, you know, go back up if you know, either side seeks cert from whatever this court does now. And that's the first thought. The second thought is, more generally, it's a system of precedent, and they have said again and again and again that their shadow docket orders are not rulings on the merits, and they're not precedent. And so, you know, I don't think that it's sort of proper sort of judicial decision-making to, with respect, it's not for me to say, but you know, my intuition, or my feeling about this subject is, and it makes sense, I think, that you have to only follow law, and there's no law that's made in the order, so there's no way that you can divine a legal rule out of these two paragraphs.
So how do you interpret what the last paragraph, where it says this order is without prejudice to any challenge to Secretary Noem's February 3, 2025 vacatur notice, insofar as it purports to invalidate these various things, issued with October 2 expiration dates?
Thank you, Your Honor. That was the third thing I was going to say, actually. So the second paragraph of the order suggests that one might be able to bring a claim to protect people who have already had documents issued under the January 17th extension. And we've done that, and the court ruled in our favor. So there's a small number of TPS holders now.
Individually.
Excuse me, Your Honor?
These are individual claims.
No, we did it in this case.
Oh, okay.
We said, and the district court agreed, that all the people, we don't know how many, it's a small number of people, but all the people who did get documents under the January 17th extension can keep their jobs. And depending on what document they got, a very small number of them do have protection from detention and deportation. The only reason I bring that up, and as your question suggests, that suggests they didn't think there was a subject matter defect, because if there were a subject matter defect, then presumably this claim, which we now have a separate order, which is not before this court now, but a separate order protecting people from, that too is a challenge to, on their view of determination. If determination is everything related to TPS, and not only the things that actually the secretary determines in subsection B, which is our position, but if that their view is correct, then that claim would also be barred, and that second paragraph, the claims in the second paragraph would also be barred. So I don't think that if we're playing this game of reading tea leaves out of two paragraphs where there's no law in it, I wouldn't think that the answer would be that we should lose on subject matter jurisdiction because of that second paragraph.
Could I take you to the framework for the equal protection challenge? I'm just trying to, we've referred to Arlington Heights for some of these pieces. Should we draw any distinction between, so the DACA case, which was Arlington Heights, dealt with a defined population of people. The Hawaii case, I think like this case, deals with the designation of a country. And so I understand that animus is disqualifying whatever standard, right? Animus is the one irrational basis in constitutional law, but why doesn't that suggest that where we're dealing with a government action, where the classification is really a country as opposed to people, rational basis is where we start?
I think the relevant distinction that Hawaii drew is not whether or not the distinction is on a country-by-country basis. I don't think you'll find that in the rationale given for the opinion for why it's applying deferential facially legitimate.
Right, I looked for it when I was trying to understand it, but you're right.
Yeah, no, I think what they're saying, they say a few things, but the one which they say, which is most sort of canonical immigration law, is that the claims are on behalf of people who are abroad.
Yeah, but the problem
trying to
there
seek
is that
admission.
it not only doesn't make sense of Matthews, but it also doesn't make sense of all of the rest of rational basis review under Cleburne and Romer and other cases, which of course we will apply rational basis to citizens who are bringing equal protection claims.
Yeah, absolutely, Your Honor. I think this is a doctrine that a most deferential standard of review, which seems to get sort of plopped into certain spots. Moreno and Cleburne are not these sort of historically problematic classifications like racism or race and gender. They also use it in selective enforcement claims. Those might be for people who are in the country, so that seems to, it's not the same as what they're doing in Trump v. Hawaii, but they have used that. The Supreme Court hasn't, but they've sort of blessed the Second Circuit doing that in a case called Raja v. Mukasey. So they treat somebody who's already lost the right to live here, but they're saying, oh, but I'm being targeted because of race. They treat that kind of like the person who's already abroad. So it's ad hoc. I concede it's ad hoc, but you will not find a case involving people who are in the country, and particularly lawfully in the country, like our population, but even people who are not lawfully in the country, people who are in the country, where the Supreme Court has said as to a claim about racial animus, that what is to be applied is this very deferential Trump v. Hawaii standard. In fact, I don't believe you'll find a circuit court that says it. We cite the Second Circuit's opinion in United States v. Susquehanna. It's a 1320.
But I guess on the other side, can we find a case, a Supreme Court case, maybe one of our cases, but let's start with the Supreme Court, in which they've assigned animus to the executive and invalidated an executive action or agency action based on such animus?
Well, they assume that the standard of review adopted by regents, Judge Wardlaw's decision for this court, they assume that Arlington Heights applies in that context. That's one. Another one, I would say,
But they rejected the assertion of animus.
On the merits they rejected, because they said the statements are not close in time, they're not about DACA, which is absolutely the opposite of what we have here. The other one I would say, look at the vacated panel decision in Ramos, because they considered the same question and also decide that Arlington Heights applies. And then the third one I would say, I agree, this is not a Supreme Court case, but that Second Circuit case, United States v. Susquehanna, which is a 1326 case, it's a challenge to the illegal reentry statute, on the criminal illegal reentry statute, on the ground that its origins are motivated by racism. And that court considers the government's argument, they made the same argument they're making here, that because it's sort of immigration policy, you have to apply, just generally, all immigration policy, you have to apply extremely deferential review. And the court rejects that, and it collects a whole load of cases from across the circuits, various contexts, the public charge challenge, the rescission of the public charge program that happened in the first Trump administration, and various other contexts. And they say, look, it is not the law that just because it's immigration, we apply some deeply watered down form of rational basis review. So I think that's the authority that I would cite for that context. I don't think that, I agree that there's not a Supreme Court case that squarely decides that question one way or the other. I see my time.
What position do you take with respect to how the Secretary could have lawfully terminated the TPS status? Because I understand your argument. You're saying that allowing the vacatur would actually contravene the statute because of these extension periods and termination notice dates and all of that. So what do you think the Secretary should have done?
I mean, once the designation is in effect, the TPS statute is very clear. It lasts until the end of the extension. So in summer of 2026, that's when it comes up. And I know in this hyper-partisan era that feels like somehow unfair, I suppose, to the party that loses the election or that wins the election. But Congress wrote this statute not imagining that administrations should get to play like political hot button with the lives of so many refugees. That's not the statute that Congress wrote. They wrote it to create stability. They wrote it against a backdrop of cases like the case they cite, which is over the hotel restaurant workers DC Circuit opinion, which is overruled by the TPS statute. That's the TPS statute comes into place and says, it says we're designating El Salvador. Congress designated El Salvador in 1990 by statute. It directly overruled that case, but beyond that, they created a regime where there would be some amount of predictability, and that predictability was meant to apply even during times of political change in the process. Any other further questions? I don't know if the court wants to talk about appellate jurisdiction at all. Perhaps not, but
Well, we do know we have a case that has priority on us on the question of appellate jurisdiction.
If I maybe just say one very brief thing about that, then
Okay.
in that case, Your Honor, I would just note that in our case, this order just postpones two decisions. That's all it does, and reverts us to the last uncontested party status between the parties, which is the January 17th extension, right? That's all we do, and it doesn't direct the agency to do anything at all, just postpones these two prior ones.
But I think this case is a 705 case too. Is any reason we should distinguish between 705 stays?
I think so, actually, because I think it depends on what the underlying administrative process is at the moment when that change happens. So like in that case, and they may well be right as well, I don't want to sort of throw them under the bus or anything, but in that case, the MPP program has stopped. And I think that at least the parties argue about whether the effect of that is to require them to go back to a position that existed a number of years before. Here what we're talking about was a decision that required the agency to just keep TPS running as it was supposed to be running on January 17th. And then there's the other thing, I'm taking too much of your time. The last thing I'll say about that is the district court had a long discussion from page 17 to 22 of the excerpts of record about why this order was not injunctive, because it was at issue for 1252F, for the other jurisdictional provisions.
But depending on the length of the proceedings, couldn't it just end up being dispositive, given that we're talking about temporary relief anyway?
Well, here, summary judgment is, maybe this is to answer your question. The summary judgment hearing on the APA claims is August 1st. Does that answer your question?
It gets there, yeah.
Yeah, so August 1st, so I think there will be rulings very soon. They're hearing anyway, very, very soon on the APA claim. Thank you, Your Honors.
Thank you, counsel. I'll give you 2 minutes to respond.
Thank you, Your Honors. 4 quick points. First, they concede that the agency has authority to correct ministerial errors under this TPS statute, and they identify no textual basis that would allow this court to draw a distinction between ministerial errors and policy-based errors.
But, Mr. Ensign, you say policy-based errors, and I'm not sure I understood your answer to this question. Does the secretary, is there anything that should suggest to us that the secretary believes that Secretary Mayorkas's order extension was unlawful?
Yes, Your Honor.
Where is that in the record, and what is that basis?
It is in the vacator decision. She specifically said that his prior order that, quote, "the explanation for operational impacts was thin and inadequately developed," that would render it unlawful. She also pointed to the fact that it would extend designations by up to 13 months. That is not a lawful period under the statute. The statute permits extensions for 6, 12, or 18 months. 13 months is not an allowable choice. Those are both legal errors that were identified in the vacator order, and certainly as to her rationale that the explanation in the prior one was thin and inadequately developed is completely untouched by both the district court and plaintiffs. And that alone is a sufficient basis to uphold the vacator decision under the APA.
Actually, if you could answer one of the questions, I understood your answer to my question about the language that was used. You were suggesting that that was some time prior to the secretary entering office. It doesn't seem like it was. Was that right? Did I understand your answer right?
I don't believe so, although it's also possible that I misspoke, Your Honor. I was saying that the majority of these statements were made when she was out of office.
Because on January the 29th, that's when she made the dirtbag statement, is that right?
That's roughly my understanding, Your Honor.
That was after she was the secretary?
Yes, that isolated statement was made while she was secretary and was referring specifically to the context of TDA gang members. Those are not warm and cuddly people. The secretary is allowed to express disapproval of gangs that, commit kidnapping, terror, human trafficking within the United States. She might have used colorful language, but that is not a violation of the Equal
About the
Protection
Meet the Press interview.
I'm sorry,
The
Your
Meet the Press interview after she did the vacatur.
Well, I'm sorry to interrupt, but I want to come back to your statement because that's actually incorrect. Her statement was, quote, "Listen, I was in New York City yesterday, and the people of this country, Venezuela, want these dirtbags out."
Your Honor, the context around that discussion was previously referring to TDA members. That is not that specific sentence, but the context surrounding that discussion was about TDA members, which is an extraordinarily violent and dangerous gang operating with the United States. I also want to correct that it is not, in fact, a myth that TDA took over apartment complexes in Colorado. There is a dispute as to how many complexes that was, but it is absolutely not a myth. And I will admit that's not specifically in the record here either way, but like I will tell you from other cases, that is not a myth. That is very, very true.
Did the government move to withdraw their TPS status if those people had TPS status?
Absolutely, Your Honor, but again, that does not supplant Congress's mandate that the secretary
I mean,
shall.
you're saying absolutely not, it's an option that they actually acted on that. They exercised the authority that they already have under the statute to address individual cases of criminal conduct by beneficiaries of TPS.
That tool continues to exist simultaneously with the secretary's both authority and simultaneous mandate that she must terminate TPS status when the conditions for it no longer apply.
And counsel, to be fair, reading the entire paragraph of her statement, it does appear she is referring to TDA.
Thank you, Your Honor. That's certainly our point as to that particular statement. And just to be clear as to the timing of them, I believe it's the case with the president's statements that those were all out of office or prior term. It's the case with Secretary Noem's that the majority or most of those statements were when she was not in office. I will acknowledge, and if I said something contrary, I apologize, that particular comment was when she was in office. But unless they're singularly saying that invalidates an entire action, that's the context in which we are before you. If I may just very quickly, they have offered two bases for why rational basis review doesn't apply, and we think that they're rejected by both case laws. They say that it doesn't apply to people that are inside the U.S., but that is squarely contradicted by the Matthews case, which the Supreme Court favorably cited. They say it doesn't apply where there's animus, but that was also, the district court had found animus in Matthews, and the Supreme Court did not modify the rational basis standard to account for it. And then,
do you agree that we can affirm the district court order if we just reach the first APA claim and decide that the secretary did the statute does not authorize the vacatur because of the monthly provisions and all of that? Do you just agree with that simple proposition?
partially, Your Honor, because there's the antecedent question, of course, as to whether or not the jurisdictional bar applies. But assuming that you had jurisdiction and assuming that you thought that they prevailed on an APA arbitrary and capricious challenge, notwithstanding our arguments, that would be a singular basis for affirmance. Because that is a sufficient.
I'm saying that. I'm saying that she exceeded her, if we just decided she exceeded her statutory authority.
If they were to prevail on that particular APA claim and this court had jurisdiction to do so, that would be a basis that could be justify the district court's order. We haven't talked about scope either, so I think you would still have the scope questions, both because of CASA and 1252F, and this relief is overbroad, and you would.
Are you contesting our appellate jurisdiction at all? I mean,
Not in the slightest, Your Honor, and in fact, this is something that, went. If you look at their answering brief, they didn't think so. The Supreme Court also seemingly didn't think so, and that's not a court that's insensitive to jurisdictional obstacles. They're in fact hyper attentive to them. And I think there's a tell in their appellate jurisdiction arguments too. If you look at footnote 2 on page 13, they say, just as the Supreme Court might have had jurisdiction over an original application under Rule 23, so too might this court have jurisdiction to entertain a motion for postponement under Rule 705 if such a motion were denied in the district court. So they're not only are they not saying that 705 stays aren't potentially appealable, they're carving out a potential asymmetrical rule that they could benefit from. If they don't get a 705 stay, that apparently is appealable. But when you have a 705 stay that operates against the government in a way that's indistinguishable from a preliminary injunction, which was specifically its issuance was based on analysis of the winter preliminary injunction features. I mean, this stay walks, talks, and quacks like an injunction.
Mr. Ensign, I wonder just if I could maybe have the benefit of your big picture view in the department. So you raise the CASA question
Yes.
with respect to the universal relief here. What difference is there between the 706 vacator issue that they saved in footnote 10 of that decision and the 705 relief here? Why should we not view the Supreme Court as explicitly not having applied the rationale of CASA to this posture?
Your Honor, I think for 705 differs from 706 in its language. 706 does have a shall in it, which may be relevant, but in particular, 705 makes clear that it is applying traditional equitable principles. It specifically refers to preventing irreparable harm and maintaining the status quo. Those are quintessential preliminary injunction sort of considerations. CASA is based on traditional equitable principles, and no one disputes that whether or not to grant a Section 05 stay is governed by those same traditional equitable principles that we're controlling in CASA. And so for a Section 705 stay, and the tell in particular is you're using the winter injunction factors to determine whether or not you should do it. There's no question that those winter injunction factors are based on traditional equitable principles. And CASA tells us that under traditional equitable principles, you cannot issue universal relief to non-parties.
all right, thank you, counsel. I gave you 2 minutes. You took 7.5.
I apologize, Your Honor. I hopefully some of that was useful.
Yes.
Thank you very much.
We did ask
Thank you,
you
Your Honor.
questions. All right. National TPS Alliance versus Noem is submitted, and this session of this court is adjourned for today. Thank you.
All rise. This court for this session stands adjourned.